Sued by a debt collector? Here are tips on how to win without paying practically nothing. Here with consumer warrior John Skiba. John, good to see you.
Hey, Phillips, good to be here with you.
So, John, you're sued by a debt collector. What are the simple things every consumer can do without hiring an attorney just to get out and sometimes pay practically nothing?
It's a good question, and it's a huge issue. Debt buyers, these debt companies that buy debt and sue people, they file lawsuits in gigantic volume. The typical large debt buyer files over 500,000 lawsuits a year throughout the country, which is, and that, there's many of them. There's smaller debt buyers. So a lot of people will see themselves get impacted by this, where they get served with a lawsuit. And what I thought we could maybe do today is just talk about a few tips and strategies that I have used in my 23 years of doing this. I've done over 400 trials against original creditors, debt buyers, these debt collection lawsuits. And I thought maybe we could just touch on some of the things that I have seen, not only in my own practice, but what I've seen consumers who are representing themselves do to really prevail on that.
Fantastic. Let's go. Yeah.
The first thing I see, and this is going to sound dumb because it's a simple thing. It's not some grand legal strategy. It's not something the lawyers need, but it's simply just showing up and being there, participating in the process. 95% of people who get sued by a debt collector don't respond to it. They don't file an answer. You don't file an answer, the game's over. The judgment's entered, you're facing wage garnishment, bank levy. It's probably going to force you into a bankruptcy. Nothing forces bankruptcies more than wage garnishment. The statistics are 70% of the United States lives paycheck to paycheck. And if all of a sudden somebody says, hey, we're going to take a quarter of your check, you can see that can create a disaster for you really quick. The bankruptcy can stop that, but if we want to avoid that whole path altogether, participating in the process and filing the answer timely, whether you're doing it yourself, hiring an attorney, whatever you're doing, getting that answer filed. And I'm going to kind of sheepishly admit that I have won a lot of cases in my career simply by showing up on time to court hearings, making sure that I'm filing the documents correctly. I've done a number of trials where I show up early and I make sure I'm on time, and the attorney for the debt collector is late, and so the court just throws it out. Courts run very tight ships. Just they have to. The volume of cases that they deal with, it isn't something where they can just let things slide, or if people don't show up and if they're not participating, usually it's the end of the road for that party. And so I've seen consumers who will file their answer. They'll make sure if there's a pretrial conference, they show up early. I tell people to do things like drive to the courthouse the day before. If you're going to have a trial, go look at the court's calendar and go sit in the back and watch how a judge does things. Make sure that you're there 30 minutes early.
Know where to park. Know where to park.
Know where to park.
Yeah.
If you're in a big city, sometimes that's the hardest part of the process is knowing where to park and knowing which courtroom is and how to check in and how to get through security, all those types of things when you actually have to show up. In now the post-COVID world, knowing how to use a Zoom platform, most of the courts in Arizona where I practice, everything's done via Zoom or some kind of Teams type thing. Microsoft.
I was going to ask that. So you're saying that going to court is not always going to court. It could be just like this.
Correct. And I can tell you, I used to be in court 5 days a week. It's rare that I go once every 6 months now. It's almost all done virtually. And so understanding how to use the platforms that the court uses, understanding what they're asking you to do. If there's a date, you need to comply with it. Because so many consumers, particularly the ones that represent themselves, they don't meet those deadlines. They don't participate in the process. They don't show up. They don't file a document, and the case is over. And that's what the debt collectors and their attorneys are counting on. They're counting on that they know the system, you don't. And so just showing up, that.
So the first step is just show up, be on time, be a couple minutes early, whether Zoom or in person, just show up.
Yeah. Making sure you're reading everything that's sent to you. Don't assume anything. It's not a bad idea to get an attorney, but obviously a lot of times people can't afford attorneys, or, it doesn't make sense. If you're getting sued for $1,000, not a lot of attorneys are gonna be able to take that on in a cost-effective way for you. So, just participating in the process would be my first bit of advice, which is, that's free. Anybody can do that, is making sure you're participating. Second thing I'd recommend, an approach that I have used in my own practice, and I've seen a lot of consumers who represent themselves do, is to push the case completely out of the court system into private arbitration. Now, not every case this is eligible for this, but most are. And how you know this is if you get sued by a creditor in typical, a justice court, small claims, or even like a superior court,
Mhm.
eventually they're going to provide you, the creditor's going to provide you the terms and conditions, essentially the thing that they send you in the mail when you open up a credit card. And you need to look, and if there's an arbitration clause, which there is in almost all credit card agreements, that allows either party to say, I don't want to deal with this dispute here in a formal courtroom setting. I want to go to arbitration. Arbitration, the way to think about it, is kind of like in more of a less formal proceeding. Um, and it's managed by private companies. The biggest one is the American Arbitration Association. And what you can do is you can file a motion with the court and say, hey, judge, I don't want to deal with this here. Their contract says we can get this out of the court system
Right.
and go to arbitration.
Yeah.
There's a couple benefits to doing that. One, if you're in arbitration, the rules are relaxed. It's much simpler for someone who is representing themselves to navigate that. Whereas the courts have rules of procedure, rules of evidence. It gets really frustrating when you're representing yourself because you're not familiar with all those technicalities and you can lose because of it. You get into arbitration. I did an arbitration recently. The arbitrator showed up in jeans and a t-shirt, and it was done via Zoom as well. I mean, it was something where the rules aren't.
Zero, especially for non-lawyers. We're not, I mean, I would feel intimidated going in, right?
Yeah.
To a court setting.
Yeah. And so the arbitration is much less formal. The other thing that's kind of the underlying secret to this too is that most creditors, they don't want to go into arbitration, and they don't want to go in there for a couple reasons. One, the law firms that file debt collection lawsuits in huge volume, they do it with relatively few attorneys. Most of them have 4 or 5 attorneys, but they file thousands of lawsuits. And that's because they have a well-oiled machine
Mhm.
that kicks out these lawsuits, the complaints, the documents. And arbitration is like taking a big old wrench and throwing it right in the gears.
Got it.
They don't deal with it a lot. And so it kind of throws off their system. The second is it's super expensive for them to litigate cases there. For AAA, the American Arbitration Association, for example, if you go there and file, there's different filing fees for the consumer as opposed to the creditor. The consumer pays about $200 to go into private arbitration, whereas the creditor is required to pay anywhere from $2,500 to $5,000 upfront
Sweet.
to litigate the case.
So it's a sliding scale type thing, depending on whether you're a consumer or a business or whatever. Got it.
Correct. Yeah. Corporations, businesses, they have to pay a higher filing fee. And if you're being sued for a relatively small amount, if you're being sued for $3,500, you can see real quick the creditor's not going down this path. One, it's out of their wheelhouse because you're in arbitration, not the court system. And two, they're gonna, here's a company telling them pay us $3,000 so that you can maybe collect $3,000 on the
So
back end.
they're just gonna like just dismiss the lawsuit at that point.
Correct. Usually they'll just walk away. And you enter into a formal settlement with saying, look, we'll just call it a mutual walk away. We're not going to pursue this. The debt's gone. And then you don't pursue it in arbitration.
So let me just, so I understand this. So someone gets sued. The first step is to respond to the lawsuit as you said, in a truthful manner, right?
Correct.
And you respond. Then they have to give you over the next couple of months all the data. That's when you have your agreement. You get the agreement and you're looking, is there an arbitration clause? If
Correct.
there's an arbitration clause, you ask the court, hey, I have the right to take this to arbitration. You pull it out of arbitration, and then that's where we get to that point, right?
Correct.
Wow.
And one quick
That's a great idea.
One quick tip and resource. If the Consumer Financial Protection Bureau, which still exists as of the recording of this video, I don't know if it will in the future, but the CFPB, the Consumer Financial Protection Bureau, it's a government agency. Their website has a whole database of pretty much every credit card terms and conditions ever in existence. You can go there and download those for free. So even if you can't get it from the other side, which you should be able to, but that's a good resource where you go get that for free.
But that is a fantastic. I've never heard that loophole. I've never heard that loophole. That is, or not even a loophole. It's just a defense. A true defense that they have in their own terms and conditions. Why would they put that in the terms and conditions?
And it's a good question. The reason why the creditors put it there is because it benefits them and it helps reduce class action lawsuits against creditors.
Oh, God.
They put it in there because not because they want to help consumers, but because it benefits them overall as far as their exposure to some of these bigger class action suits that get brought against, large companies sometimes. So, and like I said, I don't know if it's a loophole per se, but it is it's their own agreement.
Fair defense. It's a fair
Correct.
defense.
Fair defense. My one caveat to it is I always say you have to pursue this in good faith. If you take it out of court and go into arbitration, I always recommend the consumer file, go to AAA. You can do it online. Literally takes about 10 minutes. Pay the filing fee and be ready to proceed. I have had creditors follow me in, and we actually litigate it and let the arbitrator decide. Sometimes I see people think, "Oh, I'm just going to file it," but then I'm not going to, or I'm going to ask for the court to give me into arbitration, but then I'm not going to pursue it. That's not a good approach.
No.
You need to have good faith in going into it, but I can tell you most of the time the creditors.
Well, I mean, if they ask go to arbitration and they don't go, then they're going to get default judgment against them, right?
Correct.
Yeah.
Which the court will just throw it out. I've had that where the creditor comes in, they refuse to pay the filing fee. And so the arbitration, they say,
Let's
okay.
not be penny smart and dollar foolish here, right?
Yeah. So they just dismiss it.
Okay, next idea.
Final idea is the option that I give everybody, the nuclear option. I give a bankruptcy filing.
Yeah.
Obviously, I say no one wants to file it. I meet with people literally every single day here in Arizona in my practice, talking about bankruptcy. Nobody calls up just super excited about the conversation.
Yeah.
But sometimes it is the best option. And particularly if you're being sued for larger amounts or there's multiple lawsuits.
Yeah.
A lot of people say, I'm so unlucky because all these lawsuits hit at the same time.
Yeah.
It's coordinated. The credit bureaus sell something called a trigger report to creditors where they can subscribe to a service that says when there's a change in your credit report, it lets them know about it. If you buy a house, if you buy a car, something that gives them some indication that you may be in a better situation, you'll see all these lawsuits start pouring in. And that's why, because
a trigger report.
Correct. If you research it, I always say the credit bureaus are not your friends. We treat them as these quasi-governmental agencies, but they're making money on both sides of this thing. Yeah. So, but anyways, if you're dealing with multiple lawsuits, you may need visiting the bankruptcy option. I always say talk to a bankruptcy attorney. They do free consultations almost across the board.
Yeah.
You'll get some peace of mind and at least some information to know, hey, is this a better option than me trying to piecemeal attack all these different creditors and trying to settle things with money that you may not have. The bankruptcy is it levels the playing field. You file that thing, it stops the lawsuit, gets rid of the debt, gets rid of any other personal loans, credit cards, medical bills, all that can go away completely. And Chapter 7's only take about 4 to 5 months.
Yeah.
There's a recovery period of time, of course, but it's generally not as lengthy as people.
Well, I recently had a friend call me and they were talking about something that went to collections and how to settle it. And I was like, threaten bankruptcy. Because if you threaten bankruptcy, they're looking at getting nothing.
Yeah.
Like it's a huge leverage point. And on your website, on Consumer Warrior, there's a link. You can, if you're in Arizona, you'll get passed to John. If not, there's a network of bankruptcy attorneys around the country, debt attorneys who can walk you through options. With regards to bankruptcy, people are embarrassed. They're ashamed, but they don't realize is that if people are walking around the mall with like a sticker of who filed bankruptcy, they'd be like, what?
Yeah.
Like, that's the thing. Like, people don't realize how common it is in our society.
Yeah.
And it's not something that people take advantage of. This is a whole thing that, like, people think bankruptcy is, they're like serial bankruptcy filers. That's very, very, very rare. Like, I don't know what percent, but very, very rare. I mean, people who file bankruptcy, most of the time it's because of loss of job, car accident, something like that, out of their control, and they just can't catch up.
Yeah.
And that's why we have the bankruptcy laws, right? And actually it goes back biblically, where
Yeah.
every 8 years, like, debt was forgiven. So don't get me started on that, but I'm a big advocate of that because people don't understand what they have, and it's a great way to start over. I mean,
Yeah. Yeah. I had a bankruptcy professor in law school, and he was one of the main people in the world on the topic. He wrote Collier's on bankruptcy, which is a big treatise, and he'd also go to these other countries to help them to develop a bankruptcy system. And he said, "You want to see something really scary?" He says, "Imagine a country with no bankruptcy." He said, "If there was no ability, life happens, like you say. There's medical, there's job loss, there's divorce, there's all these things that really make it difficult." Yeah, I mean, there's bad decisions, but frankly, we all make bad decisions
we all
every
make them. Yeah.
um, but if there was no ability to start over or to start fresh, that to me would be the scary thing. And so we have these federal laws in place. That professor always used to joke. He said, "Bankruptcy's in the Constitution," and he goes, "And in the main, not the amendments. It's right there in the main Constitution." This ability to get that fresh start. Yeah, there's consequences to it, but you can overcome those usually much more quickly than people who I see going through like some type of debt settlement program or, debt consolidation company, things like that. So I think it needs to be a valid option, and it's largely very private. Like you're saying, there's no stickers for,
Yeah.
it's not something that's published, online or anything like that. And a lot of people would be surprised, I think, at how many people have gone through it. It's usually about a million a year, I think, in the US.
Well,
So
I mean, if nothing else, just get the facts, right?
yeah,
It doesn't
yeah,
cost anything for the facts. So,
yeah,
John, these are great feedback. One, show up, make sure you're there, because many times these lawsuits get thrown out just because people aren't there on time.
yeah,
Or just the first one is you got to file a response, then show
yeah,
up. And the third thing is look at the arbitration idea. These are, and the fourth one is the bankruptcy option.
yeah.
So this is very helpful. John Skiba, Consumer Warrior. Thanks for watching. And John, thanks for having me on.
Hey, thanks, Philip. Appreciate it.
Mhm.